Hello everyone, I'm Aratrika Bhaumek and welcome to LiveLaw. Have you ever wondered if legal action can be taken against you for your retweets on Twitter or for resharing a message on a social media platform? I'm sure you've seen that many Twitter users put a disclaimer that retweets are not endorsements in their bio. But can such a disclaimer shield one from criminal liability? These questions assume significance in the wake of the comments made by Delhi Deputy Commissioner of Police KPS Malhotra that a person has to take responsibility for their retweets and that action can be taken against such posts on social media whenever they come to the cognizance of the police authorities. He had further underscored that even the endorsement of a view on social media becomes the view of the person sharing or retweeting it. Malhotra made these comments while speaking to a news agency about Alt News co-founder and journalist Mohammad Zubair's arrest for allegedly hurting religious sentiments through a tweet made in 2018. In this video, we will have a look at various legal provisions and important judicial pronouncements as to whether retweets or forwarding a post on social media can itself attract criminal liability. First, let's have a look at what the Indian law says. While there is no direct provision in Indian law which declares retweeting, forwarding or sharing of posts on social media to be a criminal offence, there are various provisions which provide for criminal liability under the Information Technology Act and the Indian Penal Code. Section 67 of the IT Act provides for punishment for publishing or transmitting obscene material in electronic form. The imprisonment may extend to 3 years and a fine, and the event of a second or a subsequent conviction, 5 years and an extended fine. Similarly, Section 67A of the IT Act provides for punishment for publishing or transmitting of material depicting children in sexually explicit act in electronic form. It provides for an imprisonment which may extend to 5 years and a fine. In the event of a second or a subsequent conviction, 7 years and an extended fine. Apart from the IT Act, the Indian Penal Code specifies certain provisions which may be invoked against an individual when any derogatory or offensive message is sent or shared in cyberspace, such as Sections 153A, 153B, 292, 295A, 499, etc. These offences relate to promotion of communal hatred, obscenity, hurting of religious sentiments, and defamation. Now let us look at some of the judicial decisions on this issue. In 2017, the Delhi High Court dismissed a petition of Aam Aadmi Party leader Raghav Chaddha challenging summons issued to him in a defamation case filed by then Union Minister Arun Jaitley, while leaving it to the trial court to decide if retweeting would attract liability under Section 499 of the IPC, which is the offence of defamation. Observing that a retweet brings the contents of the original tweet into the immediate attention of the followers of the user who retweets, Justice Sangeeta Dhingra observed that the question as to whether retweeting would attract criminal liability has to be determined during the trial of a case. Furthermore, the Madras High Court in 2018 ruled that the sharing or forwarding a message in social media is equal to accepting and endorsing the message. The observations were made while rejecting the anticipatory bail plea of journalist turned BJP leader S.V. Shekhar, who allegedly shared a derogatory Facebook post on women journalists. While underscoring that no one has any right to abuse women, the court had stated that when a celebrity forwards a message, people are more inclined to believe it due to their social status. Subsequently, Shekhar's appeal against the decision was disposed of by the Supreme Court on June 1, 2018 with the direction to appear before the concerned trial court for seeking regular bail. Hence, the larger question relating to criminal liability for forwarding a post remained undecided. While there is no authoritative decision by Indian courts on the subject, some of the international courts have tried to find answers to the same issue. The Supreme Court of Republic of Philippines, in the case of Jose Jesus versus the Secretary of Justice in 2014, had observed that except for the original author of the assailed statement, the rest, that is those who pressed like, commented or shared the post, are essentially knee-jerk sentiments of readers, and that it would be a near impossibility to implicate hundreds or thousands of responding friends or followers in the criminal charge. It had also been opined that this would create a chilling effect on the millions that use this new medium of communication in violation of their constitutionally guaranteed right to freedom of expression. In 2017, Zurich District Court in Switzerland had fined a 40-year-old man who had clicked the like button on a Facebook post accusing an animal defender of anti-Semitism and racism. The court had observed that by clicking the like button, the defendant had clearly endorsed the unseemly content and had made it his own. Similarly, a court in Germany in 2015 had observed that contrary to the like function, the sharing function on social media does not contain any other significance beyond the mere distribution of content, and that a sharer cannot be held liable for the shared content. In the absence of a clear authoritative judgment or a direct statutory provision on the subject, it is clear that the present question is left for the courts in India to decide based on the facts and circumstances of each case. If the act of retweeting or sharing or forwarding others' posts on social media has to be made a criminal offence, then the legal framework has to fill in the grey area in the existing laws so as to ensure that the same is not misused by the law enforcement agencies in any manner. Thank you. Let us know what you think about this issue in the comments. Keep watching LiveLaw for more updates.